Hi, I'm Ruby Steinbrecher. I'm an estate planning attorney based here in Sebastopol, California, and I just want to give you a little bit of information about power of attorney documents and advanced healthcare directives. These are really important estate planning documents that cover what happens to you if you become incapacitated. A power of attorney, also known as a durable power of attorney, and another form of this document is called a statutory power of attorney. This document is purely to designate who is helping you take care of your legal and financial affairs when you need the help. This could be because you're in the hospital, you're home with a broken leg, or you're traveling internationally and you need help taking care of something with your financial and legal needs. You designate an agent, someone who you really trust, who can take care of these things on your behalf. This document is separate and distinct from the document that authorizes someone to make your healthcare decisions for you. That is called an advanced healthcare directive, also known as a medical power of attorney for health, or just a plain old healthcare directive. This is where you designate who is authorized to make your healthcare decisions, what you want, by the people you want, and this document provides them the authorization to be able to go ahead and make those decisions on your behalf. Super important to have these in place regardless of any assets that you have, because anyone can become incapacitated. A will is a document that you create. You can do it by hand. It's called a holographic will, or you can have it created by an attorney, or you can create a form document. A will tells the court and everybody what you want to have happen when you pass away with your assets and who you want to be in charge of those assets. A will simply designates who's in charge and who gets what, but it does not keep your estate out of court. What's a trust? This is a weird concept. It's hard to wrap your head around sometimes. A trust is a private contract that you create with an attorney, and it designates who's in charge of your stuff and who gets what when you become incapacitated or when you pass away. This is the key legal document. If done correctly and your assets are properly titled in the name of the trust, this ensures that your estate stays out of probate court. This is so important for California residents. You want to make sure that your property, your assets, pass to the individuals who you wish in an easy way without the cost, time, and grief of having to have the court involved. So a trust is simply a private document. When you create a revocable living trust, it is not a separate entity. You and the trust are one and the same. You still have full control over your assets and what the trust says. You can change it at any time. This makes sure that things are as easy as possible for your family, and the government and court is not involved. Please like, subscribe, and follow my channel. There'll be tons of helpful tips and information to follow. Thanks.